A Fox surgeon now waiting for a verdict in the case of a former high school cheerleader accused of killing her newborn baby and burying that baby in the backyard. Brooke Richardson faces the possibility of life in prison if convicted. Her fate now in the hands of a jury in Lebanon, Ohio, north and east of Cincinnati. Richardson's lawyers there argued the child was stillborn. They say investigators pressured the teenager into a false confession. But prosecutors say a baby didn't belong in what they describe as Richardson's perfect life. They say she did an internet search for how to get rid of a baby. They also say on the day she buried that child, she texted her mother and boyfriend about how happy she was that, quote, my belly is back. But defense attorneys say Richardson's life was not perfect at all. Yesterday in court, a psychologist testified that Richardson said she was sexually abused as a child, battled an eating disorder, and had a personality disorder that made it hard for her to stand up for herself. Bob Bianchi's here, a defense attorney, former prosecutor. There's more to this than I just laid out, and that is, in one particular area, there's a distinct lack of there.
Yeah, Shep, as a former homicide prosecutor, I have never, ever had a case where I could not prove the cause of death. The prosecutors even admit we can't prove the cause of death. It's essential because you're saying somebody purposefully killed a living baby. Now, the biggest piece of evidence that the prosecution has is this statement that she gave. She gave two of them. I've been covering this case and watched every piece of it, and these statements are all over the place, and clearly they're using an investigative questioning technique called the Reed technique, where they're feeding her false data and accusatory. She's sitting there almost like a demure 12-year-old kid saying, well, maybe I heard some gurgling. I don't know. But when the baby was born, she was clear in the beginning. The baby was born still dead. It didn't have a heartbeat, and it didn't have any breath to it. So the question becomes, if the baby's stillborn, then it's a not guilty verdict. If the jury can't come to the conclusion that even if it was born alive, but it died because of medical reasons, it still could be a not guilty. Prosecutors are going on a wildly circumstantial case here.
I just got word, as you began to speak, that there's now a verdict.
Oh, gosh.
The reporters are in the courtroom. The verdict has not yet been announced, but there is a verdict, and we'll have it in just a moment. We'll have it when they release it. That said, what is the wisdom, and I have no idea here, I'm asking, what is the wisdom of filing purposeful murder charges when you can't even prove a cause of death? Is that unusual just to file in that way or to charge in that way?
Not necessarily. So say, for example, that you can't prove cause and manner of death, but somebody gives a confession that I killed this person.
I see what you mean now. Go
and
ahead.
then there's some substantial or a small piece of evidence that supports that. But that's not how this statement went. It vacillated up and down, and it was clear that she was tormented. She was holding the detective's hand. She was crying. She was asking for her mother. She gave multiple versions. And in fact, during cross-examination of the officers during this case, the officer said she gave so many different stories, we don't know which one to rely on. Prosecutors don't want to have witnesses on the stand saying, we don't know what version of the defendant's statement we can or cannot rely upon. All of us that have been fascinated by this case, personally, I think it's one of the more fascinating homicide cases that I've dealt with in a long time in terms of covering it, are wondering whether or not this jury is going to look at this and say, you know what, we think something went on here. It may be not proof beyond a reasonable doubt for a purposeful murder, which means she intended to kill that baby, but maybe plead or find her guilty of a lesser charge.
They did allow lesser included.
They did allow lesser included. There's involuntary manslaughter, and interestingly, just before this verdict came out, the jury asked the judge for a definition on one of the other charges, which is abuse of a corpse. They wanted a more simplistic definition. The judge said, I'm going to give you the definition that the law gives, go back in. So the question becomes, maybe they're convinced she desecrated the corpse, which is kind of maybe obvious in this case, but not convinced beyond a reasonable doubt, because they've only been deliberating a couple of hours, and they've got a verdict already.
Well, we are told the verdict is in, and you know, sometimes there's a delay. The way that works in court is they bring all the interested parties together, meaning the defense, the prosecution, the person who's been charged, and other parties. They get them all in the courtroom. Then normally they read it out from the jury foreperson and all the rest. So we should know in just a few minutes. We expect to know before the end of this news hour. Will you hang around?
Absolutely, Shep.
Thank you. There's breaking news, and the verdict is being read in the case against the teenage girl accused of killing her child purposefully. Listen.
Contact, communication, or influence during the deliberation process?
Yes, sir.
All right, please hand the verdict forms to Mr. Mullins in advance of the reading of the verdict. I want to thank each of you for your service. After this, you will be discharged from your service. You'll be returned to the jury room, reunited with your electronic devices. I have a couple of minutes that I would like to talk to you, and then we will get you on your way. You will be able to speak with anybody about the case that you would like, but you are not required to do so. Whether you decide to speak to anybody is a matter of your own free choice. Would the defendant please rise? With regard to count one, we, the jury in the above captioned case, find the defendant, Brooke Schuyler Richardson, not guilty of the offense of aggravated murder, and there appear to be 12 jury signatures affixed. Verdict form 2, involuntary manslaughter. We, the jury in the above captioned case, do hereby find the defendant, Brooke Schuyler Richardson, not guilty of the offense of involuntary manslaughter. Count 3, child endangerment. We, the jury, find the defendant, Brooke Schuyler Richardson, not guilty of child endangerment. It does say we further find the defendant did not cause serious physical harm to the alleged victim, but that finding is not necessary as a matter of law. Verdict form number 4, we, the jury in the above captioned case, find the defendant, Brooke Schuyler Richardson, guilty of the offense of abuse of a corpse. Ladies and gentlemen, are those the verdicts of the jury?
Yes, sir.
You may be seated. All right. Again, you are now discharged from all your service. Does either side wish to have the jury poll?
There you go. Again, we laid out the case just a few minutes ago, and Bob Bianchi, who's followed it very closely, predicted this is exactly how it would go down. You know, you look at her quivering there and knowing the background that you gave us and that we've read here. It's just there's no happy ending here.
There isn't, Shep, but this, based on all the evidence that I witnessed in the case, is the right verdict. Prosecutors can't be going to a court in a case where they don't know the cause of death, where the statement is all over the place. This Brooke, and look at her on TV. This is the way she was giving her interview. Maybe this is right in the statement. Maybe that's right in the statement. It just wasn't enough to prove to 12 people beyond a reasonable doubt. And may I add, Shep, the defense team did an amazing job of putting expert witnesses on, one of whom is the forensic pathologist in Mississippi, who works 99% for prosecutors. He said, you cannot make a determination on a case like this, as well as false confession experts who talk about that Reed technique. But as far as the corpse was concerned, it was always my opinion, after especially 4.5 hours, we discussed this off camera, you were right on the money when you said it's too quick for a guilty with all these problems that the government has on the big charges. But with respect to the corpse, she buried the corpse in a shallow grave and left it there. That seems to me to be an appropriate guilty verdict.
One of the arguments was, look, she was 18 years old. Not that you're a child at 18, but she was 18 years old. She had a lot of issues in her life. All of a sudden, she's got a baby here. She had a severe eating disorder, and her claim was that the baby was stillborn. And the argument was, you know, she panicked. And she had a being that was not living, and she buried it.
Yeah, I think
and she wished she hadn't.
And I think that could be a very credible argument here, but nevertheless, technically you violated the law there. And let's not forget, I think this jury said there needs to be something here, but I think that they looked at everything that went on with regard to the facts of the case. And again, the great job the defense did at cross-examining the state's witnesses, who in my opinion fell apart in many instances. They jumped to the conclusions too quickly. I mean, Shep, when have you ever heard detectives say, she gave many different varying versions of events. We don't know which one to be, but we'll believe this piece, but not the rest. She had said from the beginning this baby was born, stillborn, and all of the medical evidence that the defense put on seemed to suggest, based upon her eating disorder and the other conditions, that this was a very real possibility. When you have to prove beyond a reasonable doubt, it's not about a guess, it's not about a hunch, you have to prove beyond a reasonable doubt that baby was born. And then you had to prove beyond a reasonable doubt that she purposefully killed that baby. The evidence wasn't there.
Careful to point out, though, as you mentioned in the break and as we've talked before, this is not to say anybody involved in the process did anything wrong. The police went out, gathered what they could. Investigators did the same. Forensic teams did the same. Prosecutors came together to try to make a decision about what would be serving justice. And then two sides were presented, and a jury of her peers made the decision, and now it's delivered.
Yeah, I don't fault the detectives in the manner in which they question. The Reed technique is a technique that I employed myself and allowed to be employed.
Explain that one more time. It's basically peppering.
Yeah, it's really not giving them an opportunity to answer. It's telling them things like when they went back in the other interview, we have our scientists looking at this, our medical examiner people, that we know what you're telling us isn't true. And they start kind of like, why don't you just tell us the truth? You tell us the truth, it's going to be good for you. And eventually a person can be broken down to the point, well, either I want to get out of here, or if I tell them what they hear, it's going to go good for me. At one point in time, she says, I'm confused. You guys are mixing me up. And you don't want defendants. You don't want targets of an investigation saying they're being mixed up. This was not a sophisticated person. It wasn't a gang person. It wasn't an organized crime person. This was a very unsophisticated young 18 going on 12-year-old girl. So I think,
is that how she was described?
Oh, I mean, you could just see it in the interviews, and you saw it in court. She just was really a broken human being, and I think that really fed into the defense's argument to what you're saying. She wound up in a situation. She was very immature. She didn't know how to deal with it, and this is the manner in which she went about it.
The technique you mentioned is one that would potentially play itself after a bar fight. You got two cops there. Each are questioning someone. One is saying, okay, it's going to be fine, it's going to be fine. And the other one's going, we know you hit him first. We're positive you hit him first. If you go ahead and confess the truth right now, we will take you in. You didn't hit him first.
Right.
But applying that pressure, whether you know it or not, it's legal to tell that fib in front of that suspect.
It is, and the Supreme Court has ruled on that.
It's upheld such.
Yeah, and the interesting thing about it is that there have been instances where we're talking about false confessions, and I've seen it in my career, Shep, even as a prosecutor. It's almost unfathomable. The jogger, Central Park jogger case is one of those examples, and you can't imagine that people would falsely confess to a horrific crime they didn't commit, but there are people whose will can be overborne where they say, you know what, and I've had clients as a defense lawyer say, well, if they're saying I did it and they say they have evidence, I must have done it. And it's a really strange phenomenon, but it's led to a lot of false confession cases. In this case, relied solely on false confession. If they had medical evidence or forensic evidence that supported the confession, well, that would have been a different story.
Sentencing guidelines you point out here, 6 to 12 months for the crime for which she was just found guilty. Sentencing would be later. We don't know specifically on that jurisdiction whether the judge can go outside, but it's likely that that's a possibility. We'll follow up when that comes along.
Great, Shep.
Bob Bianchi, thank you.
Always a pleasure.
Appreciate it.